How does deportation begin? Deportation usually does not begin with an arrest, but rather receiving a piece of paper in the mail called a notice to appear. We're going to talk to you in this video about everything that happens after you receive that notice to appear. Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States, out of our offices in St. Louis, San Diego, Washington, D.C., and Chicago, Illinois. In late August 2025, the Trump administration made clear that if you apply for an immigration benefit and you have no legal status at the time that the case is denied, that you are going to be sent to immigration court. And the way that an agency notifies you that you are in immigration court facing possible deportation is by issuing you what is called a notice to appear. A notice to appear, or NTA, as we say it in the industry, is the charging document in which the government alleges why you are deportable under Section 239A of the Immigration and Nationality Act. The NTA is filed with the immigration court and it lists certain things. It's going to have your name on it. It will have your alien number on it. It will have your last known address on it. And then it will have a series of factual statements as to your immigration status in the United States. It will say something like, your name is Jim Hacking, you live at 123 Brown Street in Cleveland, Ohio with your zip code. Then it's going to say, you entered the United States on a B1, B2 visa on September 15th, 2022. You were authorized to stay for 6 months. You did not leave after 6 months. You are currently inside the United States without valid, lawful authorization to be in the United States. And then it will cite the statutory provisions that render you deportable to the United States. At the bottom, you'll be given a court location and a court date and a court time, and that will be when you have to appear for immigration court for possible deportation. Once the NTA, or notice to appear, is filed with the immigration court, the court then has jurisdiction over your immigration status and can decide whether or not to let you stay or leave the United States. The removal process has now begun. Let's talk about the main ways that cases get sent to EOIR, the Executive Office for Immigration Review. That's the formal name of the immigration court. The EOIR is where you're going to be adjudicated whether or not you get to stay here. And the kinds of things that trigger that are visa overstays, criminal activity, not leaving on time, encounters at the border, violating your status, like perhaps working on a student visa, and of course, any kind of criminal activity. These are the main ways that people find themselves receiving an NTA and on their way to immigration court. In order to understand how these pieces all fit together, you probably want to think about the different agencies involved. So Immigration and Customs Enforcement, that's the agency that is supposed to handle the arrests, detentions, and notices to appear of immigrants. Within ICE, there's a subgroup called ERO, Enforcement and Removal Operation. Another agency that issues notices to appear is CBP, Customs and Border Protection. That's for people who are stopped at ports of entry or while coming through customs in the United States. United States Citizenship and Immigration Service, USCIS, that's the agency that handles applications for immigration benefits. And a lot of times when a case is denied, now USCIS will issue not only the denial notice, but a notice to appear in immigration court. And then, as I mentioned, EOIR is the immigration court itself. That's where you have an immigration judge, a government attorney, and that's where you will appear and have your case heard by that immigration judge. So when you receive your notice to appear, obviously you want to make sure that you write down the court date, put it in your calendar, put on lots of alarms and bells. You don't want to miss your initial court date. If you do, bad things can happen, which we'll talk about a little bit later in this video. You will want to review the notice to appear to see if there are any factual inconsistencies or things that are incorrect that might make you not subject to removal or that the government might just have gotten wrong. On the day in question, you'll appear at the immigration court and you'll see the judge. And the judge will ask you, do you want to hire an attorney? If you don't want to hire an attorney and you're ready to proceed, then the judge is going to ask you to admit or deny those factual allegations, those statements of fact about how you came on a visit visa, or you came as a student, or you came as a green card holder, and then you fell out of status or violated the terms of your status. You're going to have to admit or deny each of the numbered paragraphs. Then after that, you're going to be asked to admit removability. Do you concede the fact that you are removable from the United States or not? So you can contest that. And the next question is what defenses you have to deportation. I strongly recommend that you do not go to your master calendar hearing without an attorney. The chances of success drop precipitously. That means they go like this if you go without an attorney. There are so many little hidden landmines and tricks and ways that you can really screw up your immigration status if you don't hire an immigration attorney sooner rather than later. You want them to be the ones to admit or deny the allegations. You want them to analyze whether or not you're removable. You want them to sift through the possible methods by which you stay in the United States if there's defenses to deportation. You don't want to give away the store at the initial master calendar, because you could actually get ordered deported at that initial master calendar hearing if you can't articulate why, say, you fear going back home, or why you're not deportable, or why you have some other future benefit available to you that might keep you from being deported from the United States. If you give away too much at that initial master calendar hearing, you can screw everything up. Whether you hire me or not doesn't matter. What I want you to understand is you need to hire an attorney, someone who knows what they're doing, somebody who's handled removal cases before, because you just don't know what you don't know. So we talked about what happens at that master calendar hearing, but there are certain kinds of cases in which you don't even get to see an immigration judge. And the two main issues there are expedited removal and administrative removal. So let's talk about those. Section 235B of the Immigration and Nationality Act allows for what's called expedited removal, where you get deported from the United States without ever seeing a judge, without ever having your day in court. This is primarily for people usually who get caught by or near the border and who can't show that they've been here for very long. But the Trump administration has expanded the use of expedited removal. They claim that expedited removal can be applied, and therefore people denied the opportunity to see a judge, for anyone who's been in the United States for less than 2 years and is caught anywhere inside the United States. So it used to be 15 miles from a border, but now they are saying that if they find you anywhere in the United States and you've been here less than 2 years, then you are subject to what's called expedited removal, and they can deport you from the United States. And then under Section 238B of the Immigration and Nationality Act, that's administrative removal. This is for people who are not in the United States with a green card, but rather on a non-immigrant visa. If they get convicted of committing an aggravated felony, they can be deported without seeing a judge. In those situations, the ICE officer simply issues the deportation order, and there's no involvement of the Executive Office for Immigration Review. The immigration court has nothing to say about that, and there's no serious way to challenge that. Both expedited and administrative removal are very fast. There's not a lot of opportunity for legal advocacy or for trying to stop it. A practitioner could file a lawsuit for a writ of mandamus in federal court if something's fundamentally wrong. That is, if somebody's not really subject to expedited removal, you could challenge it that way. If someone's not subject to administrative removal because of an aggravated felony, if there's a fundamental flaw in what the government's trying to do, you could challenge that in federal court. But generally, these are cases that move very quickly, and the people often end up outside the United States before a judge even has the chance to rule on it. Turning back to the typical situation in the Executive Office for Immigration Review, where somebody receives a notice to appear, gets a court date, and then fails to appear either at that hearing or at a future hearing, they can be ordered removed in absentia. What that means is you're ordered removed without you even being there, without you being part of the process to see whether or not you get deported. There's no real hearing. The judge just calls your name, you're not there, and they order you removed from the United States because you failed to appear. In order for the government to obtain an in absentia removal order, they have to show that you received actual notice of the court hearing and you chose not to appear. They also have to show that removal is supported by clear evidence. In other words, they can't just make stuff up, but there has to be actual evidence that the individual is removable. Most judges, if you don't show up, are going to conclude that you are subject to removal and order you removed in absentia if you haven't appeared in court or miss your court date. If you are ordered removed in absentia, you will be barred from coming back to the United States for 10 years, and you can't reopen it for those 10 years unless there's exceptional circumstances. So if you miss your court date through no fault of your own, like if the court never notified you or if you never received your notice to appear, and you can demonstrate that and that you have an actual defense to deportation, you could get an in absentia removal order set aside, but it's very, very difficult and expensive. Reopening may occur within 180 days for exceptional circumstances, or at any time if you can show that proper notice was not received. But again, not easy. Let's talk about some of the mistakes that we see with people who are going through the immigration process who have received that notice to appear. Number one, they go without an attorney. Number two, they concede things that they should not concede. Number three, they miss their appointment at the immigration court, or they come late. I've seen people show up 2 hours late and the judge has ordered them removed, and the judge doesn't just say, oh, sorry you weren't here at 9:30. I know it's only 11:30. They try to stick to that deportation order. Remember, the Trump team is trying to deport as many people as possible. So what you're going to see are more and more people getting ordered deported in absentia and courts fighting back on setting those aside. It's not a cakewalk to get that thing thrown out. Another big mistake that people make is they enter into an agreement with the government for what's called voluntary departure without knowing their rights. We have heard of cases of people people taking voluntary departure even though they had an actual defense to deportation. That's a big mistake, and it can really screw up your immigration future for a long, long time. So you need to be very, very careful when looking at documents and deciding whether to sign them. This is especially true if you're in detention. There's a lot of paperwork that has to be signed at that time. The government might be trying to put pressure on you to take voluntary departure. Don't do it without talking to an attorney. In addition, you should know that the EOIR is overwhelmed with so many cases. The ICE attorneys have way too many cases to handle a normal course load. They're carrying thousands of cases, and a lot of times cases slip through the cracks. So you need to make sure that you're always on top of your next court date. Even if you get a court date, it might be moved up sooner or later. You need to keep track of it. There's an online portal where you can do that. Having an attorney involved, that's a really good benefit, is that they should also get notices of any court changes. It should be in their own EOIR portal. You should be able to have your attorney check that, but not monitoring your case carefully and assuming that you're going to get the mail you're supposed to get, that your case is not going to be moved from the date that you originally received. Those are all mistakes that people make, and it leads to those in absentia orders, which we don't want you to get. The interesting thing about attorneys' involvement at the EOIR is a lot of people, with USCIS, they think, I can do it myself, or I can have a notario or paralegal or form filler help me with my immigration case. But in removal land, this is a very, very complex area of the law. The INA itself is about that thick, and the books interpreting it are that thick. There are volumes issued on all the kinds of ways that you can stay in the United States, and people just don't have a good understanding of what they're facing when they're in removal. So getting a lawyer involved sooner rather than later is really important. Before we wrap up, let's talk about defenses to deportation. So the main defenses to deportation are going to include asylum. So if you are seeking asylum in the United States and you get referred to the immigration court from the asylum office, if that happens, you get another chance at making your asylum claim in court. And one of the mistakes we see people make is they don't do much to make their case stronger. They just sort of go through the motions, and they find themselves in big, big trouble. Another defense to deportation is if you are married to a U.S. citizen and you want to adjust in court or seek termination of your deportation proceedings to allow you to adjust your status at USCIS. That's another way that you can stay in the United States. If you've been referred there because your I-751 removal of conditions petition has been denied, you can file a new one with USCIS and try to get the court to slow down deportation proceedings while your 751 is pending with the court. There's also something called cancellation of removal. Cancellation of removal, there's two types of that, and they're called 42A and 42B, and it's separated between green card holders and non-green card holders. But basically, if you can show that you've been here for a certain amount of time, 7 years as a green card holder or 10 years as a non-green card holder, there are 3,500 visas set aside every year for people with green cards and without. So there's visas set aside every year for people who are entitled to cancellation because they have a qualifying relative who will suffer hardship, they don't have a criminal record, and they've been in the United States long enough before receiving their notice to appear in immigration court. If those things are satisfied, that might be one of those situations where you are removable, but you have a defense to deportation where the judge would have to have a trial on cancellation. So that's another tool in your toolbox. And then, of course, there's always withholding of removal and cancellation of removal. So if you filed your asylum case too long, or if the court decides that you're not entitled to asylum, but that you would face some bad consequences if you were to go back home, the court could enter a removal order, but then withhold the execution of that order, and that's called withholding of removal. It's not a great option. It's not a great result. It doesn't give you a path towards a green card. It does allow you to stay in the United States temporarily at the good graces of the federal government. If they decide to change their mind, they can, and then they would deport you. Or if they are having trouble getting your country to accept you, they could change that. If the country says yes, then you could lose out there. And then there's protection under the Convention Against Torture. Again, not a great solution, but it would keep you in the United States and allow you to stay here. And again, not a path towards citizenship. So those are sort of the main things that happen in immigration court. If you are facing deportation, those are the defenses that you need to be thinking about. In conclusion, so sadly, if you find yourself in the removal process, it's obviously very stressful. You're looking at this piece of paper that says, we want to kick you out of the United States. We want to deport you back to your home country. And this is why we think you are subject to deportation. This is why we believe under the law you are subject to deportation. And this is why we think maybe you're subject to mandatory detention because you've committed certain crimes or you don't have defenses available to you, that you're going to be in detention. These are all big, big issues. Detention we cover in another video topic. But you need to understand that if you're in removal, it couldn't be any more serious. They are trying to deport as many people as possible. Stephen Miller and Donald Trump have given ICE quotas of somewhere between 3,000 and 7,000 deportations a day. They want that machine going as fast as possible. So if they can do anything to strip you of your rights, to not educate you about your rights, and to get you deported out of here as fast as possible so as to make the people at the top of DHS happy, that's what they're going to do. If you want our help in trying to see if you're eligible for bond, trying to see if you have defenses of deportation, looking at your NTA RTA to see if you want to hire us, working together and trying to keep you here and raising defenses to deportation that you may have. We'd love to work with you. You can call us at 314-961-8200. Email us info@hackingimmigrationlaw.com. If you're just looking for free resources, we have a ton of them. You can join us on Facebook. It's the Immigrant Home. You can find it on Facebook. There's over 15,000 people there talking about deportation and immigration. You can join our YouTube channel and subscribe. Turn on your alert bell so that whenever we post a new video like this one, you get alerted. And then make sure to follow us on TikTok at Immigration Hacking. Finally, you should know that I go live 3 or 4 times a week on YouTube, Facebook, LinkedIn, and Twitter, and TikTok, talking about the immigration process. And that's called the Immigration Answer Show. That's me on the air for an hour and a half, just answering as many immigration questions as I can. Thanks so much for watching, and we'll see you on the next video.